that correct? All right, I'm not going to bring the jury out.
Siamo in
just to get them
ritardo.
back in. So when after we finish our motions and they come out, I'll let you say that, yeah, okay, let's just do it that way. All right, so based on them resting, you have a motion? Yes, ma'am. And I did receive your memo ahead of time, so I have reviewed that.
Motion to strike. Ragazzi, comunque
Okay.
sono stato malissimo stanotte, sto veramente una chiavica.
I think it's just going to be oral arguments.
Provano a chiudere il processo di nuovo? Motion to strike, di nuovo?
Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chu for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the
Vogliono chiudergli 100 milioni.
statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
Vogliono chiudergli 100 milioni di controcausa.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is
Iniziano così.
no record evidence whatsoever that Mr. Depp even saw any of the three statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief, and it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the three statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia,
La chiudono così?
476 at 2013.
Ci sono due cause in corso, Mirko. Johnny cita lei per il Washington Post 50 milioni. Lei cita lui per 100 milioni per le dichiarazioni di Waldman. Quello che l'altro giorno diceva che non poteva dire niente per segreto professionale.
369 at 372, a 1972 case. See also Jackson v. Hartig,
Grazie,
274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the three statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability, because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has
Ora
no
vi dico dei
evidence of
caricatori un
direct
attimo,
liability
che vi dico anche che cosa mi è
and
successo
cannot
stanotte.
prove actual malice by Mr. Waldman when making the three statements at issue. It is
Anna, gli stanno chiudendo il
that
processo.
Mr. Depp did not make any of the three statements at issue in Ms. Heard's counterclaim.
Cioè, ovviamente vogliono chiudere la sua accusa ai 100
In
milioni.
order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make
Non è la ringa. Motion to strike l'accusa di Amber.
On the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the three allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency.
Qua ha senso, punto.
Again,
per me gliela chiudono.
Noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was sued.
Johnny ha citato lei per 50 milioni per un post nel Washington Post. Lei ha citato lui per 100 milioni per 3 dichiarazioni del suo ex avvocato. E lui ieri hanno dimostrato che non si può provare il fatto che Johnny sapesse di quelle comunicazioni, pertanto la causa non ha senso.
Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. C. Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Corp. Versus Alston, 236 Virginia 152 at page 156. Which standard Ms. Heard has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well-settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp. Versus Holbert case, 227 Virginia.
Non c'è una prova che Waldman fosse effettivamente sotto gli ordini di Depp.
Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false. And Mr. Depp's knowledge cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Heard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim.
Avete capito perché lui non ha parlato fino adesso?
The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day,
È il final boss,
that Ms. Heard's
Beppe.
claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page.
Vero? Non volevo commentare nessun media, ma è fighissimo quel vestito.
All of that. But his testimony that two trained police officers, Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forums at various times that there were no injuries to her face whatsoever between May 21st and May 27th,
Esatto,
2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman cited, they include Laura DeVenier, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the
Non siamo alle ringhe, ma la sta sfondando. Vogliono chiudere la sua causa da 100 milioni.
The sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal.
Certo, Waldman non è un suo dipendente, è Johnny che è il cliente dell'avvocato. Johnny non è responsabile per quello che fa l'avvocato, perché non è il suo boss, è l'avvocato a essere in questo caso l'indipendente che serve Depp per i suoi servizi, ma non come responsabilità.
1995, where Judge Ellis, a legendary
Fornitore, grazie Beppe.
by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results, or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp
è stata la prima domanda.
None of his loan-out companies have
La prima domanda che lui ha fatto a Waldman è stata: tu hai una tua firma legale? Ok.
Other than in addition to Mr. Depp, and that's found at the transcript, page 6020 through 21.
In questo caso il giudice Peral.
All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim,
Giudice.
is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion, entitled to protection under the First
Non stanno scaricando il barello all'avvocato, perché l'avvocato non ha mentito, per cui non ha colpa nemmeno l'avvocato.
US 323 at 339. That's a 1974 case from the United States Supreme Court.
A differenza dei loro avvocati, che anche loro avevano provato a chiudere il caso, ma gli hanno sbattuto la porta in faccia.
83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view.
Sì, in poche parole sì, stanno dicendo se vuoi fare causa, fallo con l'avvocato, non con Depp, sapendo che comunque l'avvocato però ha ragione.
Personal conclusion, unquote, and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the parties' marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid, where Mr. Waldman's statements
in realtà ha rifiutato dicendo che non le aveva ancora viste tutte, Ana.
Were clearly expressed, and Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view.
Mentre invece, secondo me, la mozione che stanno muovendo è corretta. Non perché sono di parte, ma onestamente, dopo tutte le testimonianze che abbiamo visto, è palese che lei non ha un cazzo in mano. I 100 milioni li ha tirati fuori dal cappello. Tutti quanti dicono che non c'entra una mazza. Oggi so anche che deve testimoniare il capo di Warner Bros. A dire che le dichiarazioni di Waldman non c'entrano niente con la scelta di rimuoverla.
Which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant
Bravo,
part,
Sergentone.
quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it. What he is suing about here are the 3 statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor.
Overruled! Coglione! Overruled!
What Mr. Depp is suing about are the 3 statements.
Può
And
continuare.
It's very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those 3 statements were related to Mr. Depp, because otherwise nobody had any interest in the article, and it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of
Yes.
popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the 3 statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the 2 litigants in this action anymore.
Lui guarda
than
il cielo
Mr.
perché ha già
Waldman's
capito.
statements. I mean,
Ha fatto vedere.
adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the 3 statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU
King
working
è il
around
mostro
the clock
finale,
with
li
Eric George
sta asfaltando.
to be as clever about this as
Sta
possible.
parlando
And Your Honor,
per
remember
annullare
the
la
testimony
causa
of Mr.
di lei
Doherty
nei
about
confronti di lui di
consternation
100
of the
milioni.
ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed
E in
evidence
una
from
mossa
the
sola
ACLU
sta invalidando i claim di lei e dando credibilità ai claim di lui. Cioè, una mossa pazzesca.
He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about that was either a reference to this game they were playing with the op-ed or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but
Certo,
we
Juventus.
have evidence that she refused to sign the pledge card. So, she's caught either way. Simply stated,
Dai, dagli il post-it,
Mr.
Tito
Depp
scappa.
is not suing Ms.
Scappa.
Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name. an act that, coming from an ex-spouse, is fundamentally personal in nature.
Sta
For that reason,
assaporando
Your
il
Honor,
dick che gli
Virginia's
stanno dando.
anti-SLAPP statute
È lì che
is
fa...
not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you.
Yes, sir.
Vai, parla, Rottenborn.
E Nato Marcio riprova a salvare ormai una causa persa, vediamo che cosa ha da dire. Nato Marcio per Ambra Sentita.
Favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom, which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction at the conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so he can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim, but as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD.
Non ha
He
mentito.
disregarded any evidence that he didn't
Non ha
believe would
mentito.
fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury.
Che però
That's
era
a
vero.
shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the three statements in the counterclaim.
In ogni caso non c'è
Your
prova
Honor's
che
heard evidence-
non
I
sia
won't
un'idea
go through all the
dell'avvocato di
evidence, Your
Depp.
Honor's heard evidence from Ron Schnell, who's
A parte che
traced
non ha
the
fatto
negative
niente di male, ma non
hashtags
c'è una
for
prova
Amber
che sia stata un'idea di
online
Johnny.
associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent
Senza contare che il faldone che ha portato all'LAPD era tutto vero, cioè le cazzate che ha detto lei erano tutte cazzate davvero.
They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that. And his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury
Ha fatto una controdenuncia, sì, ma non...
will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber
non ci sono
of
prove.
creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows, too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr.
Non è la
Depp's
finale.
as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are, as a matter of law, regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows a jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here. I'll touch on a few things.
Vai a dire le prove.
One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu, feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also plenty of evidence that's been produced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the
pieno di prove, ma non ve le dico perché sono troppe.
That Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington.
Guarda, non uno di quelli che ha parlato finora aveva qualcosa di utile da dire, quindi di cosa parliamo?
Completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th.
Testimoniando anche che non sapeva da dove arrivavano.
Ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence
Christy Sexton che ha raccontato una storia diversa riguardo al dito, poi Io Tillett che prende in giro Johnny sui social media.
Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to
Esatto, Gagman.
That's fine. Thank you, sir.
Thank you.
Yes, sir?
Your Honor, I will be brief in deference to the court's time and the jury's time. What Mr. Rottenborn said
Nato Marcio.
about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear non sequitur, red herring distraction.
Nella mozione originale cioè nella causa originale non avevano mai detto che il fatto che fosse andato dalla Los Angeles PD fosse un problema.
Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole. And their
Arriverà, Invicti, arriverà.
And it's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her.
Ti servono tanti post-it.
And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children.
Lo sapevo che avrebbe avuto il dente avvelenato su questa cosa.
And that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue,
Ero sicuro che lui, se fai post-it,
and that is not sufficient.
Lui se la mangia per sta cosa delle donazioni.
That Mr. Depp was aware of these statements, and they knew that they couldn't do it, and they didn't even try. And it's more of gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman,
Immagina.
Oh, woman up, I only hit you, I didn't punch you. And when it was chilling, when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. It is an abuse of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what
Zitto.
Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right, thank you, sir. All right, in this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As
Non ho
far as the
capito.
opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are at issue in the counterclaim, ruled
Rifiutata.
that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you.
Denied,
Other preliminary
ma
matters before the jury?
ha assolutamente senso, perché effettivamente il succo di quello che ha detto lo abbiamo nell'ultima frase, ovvero che non è compito suo giudicare se le prove sono veritiere o meno in questo momento, perché appunto il problema che abbiamo qui è che ci sono delle prove che poi la giuria avrà modo di decidere se credere o meno, ma ci sono prove conflittuali tra uno e l'altro, cioè ci sono testimoni che hanno detto una cosa e altri testimoni che hanno detto una cosa che va contro, per cui non appare chiaro qual è la verità. Lei può avere una sua opinione, ma il giudice quindi non la può dare, deve essere imparziale in questa fase. Quindi in questo caso praticamente adesso ha detto la mozione non è accolta, sarà compito della giuria scegliere da che parte stare. Io ho capito così, poi se qualcuno ha capito diversamente correggetemi, ma questo è quello che ho capito io. Lo rimette alla giuria perché lei non può prendere parte. Nello specifico, se da un lato uno porta un faldone di prove e dall'altra parte un testimone dice non è vero, non ha detto proprio così, e allora dimmi, ha scaricato il barile alla giuria, questo ho capito anch'io. Nel frattempo, mentre loro chiacchierano, vi faccio vedere il caricatore. Caricatore stampato, c'è un pochino di finitura non bellissima qui, ma nel complesso il caricatore lo trovo molto bello. Loghi ben intarsiati, si innesta bene, ma non troppo, ed è il motivo per cui l'ho ristampato. Se quello è corretto, le dimensioni sono precisissime, il file è stato pulito, ho pulito la timeline, ho rifatto tutto quanto in modo che fosse più leggibile, e quello è il caricatore che vi rendo pubblico, però vi faccio vedere il fit adesso. È un po' da pulire, l'ho stampato con il brim, ma si pulisce in un attimo. Però in questo qua ho fatto la scritta safe ancora più incastrata, perché non voglio farla nera alla fine, la voglio lasciare solo incastrata. Per cui l'ho fatto molto molto più incassato di questo, non so se si vede la differenza. E sotto qua c'è il logo e ho anche scritto in basso AICS, che è lo standard di questo caricatore, in modo che se in un futuro ce ne fosse più di uno, questo è quello AICS, lo possiamo riconoscere. Pulisco un pochino la stampa e poi lo proviamo. Molto più pulito, l'ho stampato più lento perché tanto sapevo sapevo che avevo tanto tempo a disposizione, quindi l'ho stampato apposta ancora più lento. Comunque, giusto, vi dovevo raccontare, stanotte sono stato malissimo, ragazzi. Fortunatamente è saltata la lezione al poli, quindi non sono dovuto andare stamattina, ma mi sono svegliato stanotte con un mal di testa pazzesco, ho dovuto strisciare a prendere l'Oki. Non sto esagerando, sono dovuto strisciare a prendere l'Oki e sono stato più o meno mezz'ora nel letto a lamentarmi, sembravo uno zombie, facevo... non riuscivo a chiamare aiuto, giuro. Non riuscivo a chiamare aiuto. Sono arrivato, non sto esagerando, sono arrivato strisciando al mio zaino con dentro l'Oki. Poi sono stato mezz'ora senza capacità di fare un cazzo. Quando mi sono ripreso, sono riuscito a salire e avvisare mio padre, ma non so che cosa sia successo. Non ne ho idea. Non ne ho idea. Vi giuro, però è stato veramente, veramente brutto. Veramente, veramente brutto. E io non ho mai mal di testa, non ho mai niente. Quindi mi ha proprio spaventato. Vedevo bene? Sì, sì, vedevo tutto bene. Avevo solo un male disarmante. Vedevo benissimo, tutti i sensi erano a posto, avevo semplicemente un dolore immenso e se stavo in piedi mi veniva ancora più forte. Oh, ma sta stampa è venuta uno spettacolo. I supporti vengono via un piacere. Guardate che roba. Wow. Ragazzi, se non entra piango. A entrambe le tempie il dolore. Questo è quello di ieri. Ha un po' di gioco così. Ma sta dentro, cioè comunque non è che si stacca, va comunque bene. Questo gioco qua penso che sia giusto. Forse un po' stretto, ma voglio che cada quando... Va benissimo. Va benissimo. Non lo so, Pino se russo. Forse può essere un filo più largo, ma direi che è perfetto così. Risultato finale? Ho portato giù questa parete in modo che arrivasse a filo. Nel caricatore originale che avevamo progettato era più incassata. Era più dentro. Stupendo. No, in realtà mi piace così, ragazzi, perché fare la scritta nera ho visto che ha dei problemi, ora vi faccio vedere, ma in generale direi che è ottimo. Penso di non colorarla, penso di lasciarla così, chat. Tanto è palese che è sicura l'arma. Promosso! Very nice. E ovviamente non posso chiudere l'otturatore. Lo so che si vede pochino, però voglio dire, anche se non ci fosse scritto niente. No, nulla, 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 nulla. No, no, è bellissimo. Il gioco forse potrebbe essere un po' di meno lateralmente, però aspetta, fammi prendere il Mega da 10. Sì, minchia. È lui. È lui. 2,40 € a stamparlo. Devo ancora fissare alcune cose, ma c'è tempo mentre guardiamo il processo. 2,40 € a stamparlo. Very nice. È in cintura? Qual è quello nuovo? ACS. Adoro come lo sbatti dentro. No, bellissimo. Ne ho due. Allora, non lo coloro perché l'inchiostro viene trasportato attraverso i layer e sbava. Vedete come se lo porta via? E pennarello indelebile. Ma mi... Raga, mi piace più così, onesto. Mi piace di più... In questo modo mi sembra più un prodotto finito, anche perché se fosse realizzato sarebbe realizzato per injection molding così, cioè sarebbe boom boom, boom, uno dopo l'altro, ne farebbero un sacco così. Lo trovo comunque... sono soddisfatto. E la stampa alla fine è venuta bene. Mi comprerò un'altra bobina di quel materiale perché è davvero piacevole. Grazie Alex. Che materiale è? PETG. E dovrebbe essere lungo come il 10? Guardate che roba. È lungo come il 10, fighissimo. È nato come fucile da caccia, ma lo uso per tiro sportivo, Magni, sì. Non puoi andare a caccia con i caricatori maggiorati. Per finirlo del tutto, potrei prendere una stecca di metallo, scaldarla e cauterizzare queste parti qua, che sono quelle che avevano il supporto, e sono quelle venute un po' peggio. Potrei prendere tipo un coltello da burro, scaldarlo tantissimo e fargli fare solo... E PETG, sì. Oh, no, due caccole di colore. Vabbè. Due caccole di colore, ma... Ma vai di carta vetrata e GG. Ma ragazzi, è perfetto così. Figo davvero, sono proprio soddisfatto. Prossimo progetto, sai che non lo so. Rispetto al precedente l'ho fatto un filo più lungo. Un filo più lungo anche in questa direzione, con il proiettile un po' più corto. Allora, esistono degli estrusori, Santo, proprio per fare quello che hai detto tu. Sì, esistono. Solo che sono molto complessi. Hai un filamento riciclato? C'è chi lo fa? Ti faccio vedere qualche foto, magari. Ci sono dei macchinari che tu maceri tutto, triti tutto, lo risciolgono e lo riestrudono. Ci sono macchine fai da te, ci sono macchine già finite. Comunque sì, c'è chi lo fa. Come vedi però è abbastanza complesso. Per esempio, 648 euro. Forse no, eh? Ha senso se stampi un botto? Beh sì, ho stampato tanto, ma non da giustificare. Mi dispiace per l'ambiente, quello sì. Purtroppo no, non è perché non c'è più su Amazon più che altro. Va bene, Armstrong. Non puoi passare avanti. Siamo live. Con le stampanti vecchie, Trafalgar, più o meno. Oh ragazzi, è davvero figo. È solido poi. L'altro caricatore potrei usarlo per vedere quanto è resistente. Ci tiriamo una martellata. Ci tiriamo una martellata.
All right, are we ready for the jury then? Yes. Okay.
Ha ceduto. Martellata dall'alto, ceduto. Di lato. Direi che tiene. Per piatto così. Ok, fair enough.
Good morning, ladies and gentlemen. I apologize, we had a few housekeeping matters to take care of, but thank you.
I punti di rottura ovviamente sono dove ce li aspettavamo.
Defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence?
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamada.
Esattamente dove ce li aspettavamo. Nice, comunque, preparatevi, questa sarà una botta potente.
Your Honor, just to clarify, this is by deposition, so we may need
Oh,
the...
okay, okay.
I apologize.
Comunque estremamente resistente,
That's all
penso
right.
abbiate
Thank you,
visto.
If we could get, yeah.
Estremamente resistente. Walter Hamada è capo di Warner Brothers. Vice capo. Come mai non ne vuole sapere più? Trafalgar, è successo qualcosa? Hanno abbassato prioritore, seconda deposizione, spegni la luce.
What do you work for Warner Brothers Entertainment Inc.?
Yes, I do.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did
Vero,
Warner
Klaus?
Brothers have a contract with Amber Heard to perform in Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come
Strano,
to be the
Trafalgar.
president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard
Ti rispondo per
ever
iscritto.
released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies, and I think traditionally, prior to me joining the company, every option was renegotiated, and one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals, and they have an understanding that there will be options and that there is a deal in place, and it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
Lo hai un multimetro, Trafalgar?
The size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say. So, and from there, beyond normal development, the role sort of, the character's involvement in the story was sort of what it was from the beginning.
Was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Gli ha detto ci abbiamo
Was
buttato
there
al culo.
any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Ah,
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there, and would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa, and move forward that way.
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
Posso fare i complimenti postumi alla competentissima esperta di ieri?
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
And when is the last time you spoke with Rob Cohen relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been the same time that I was having those conversations with Peter Safran.
So
in 2020.
Did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
When did you speak with Jason Momoa about chemistry issues between he and Amber Heard?
It would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
Part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh, boy. I cannot tell you. Probably in 2018, latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script.
All right, what, if anything, did Rob Cohen say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there.
Sì, capisci che però intervistare questo, Umbre, annulla tutte le testimonianze che abbiamo sentito fino adesso delle opinioni.
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you know it when you see it, and the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Well, those are just, it's editorial. A good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music in a scene makes a big difference. You can make a happy scene feel sadder or a sad scene feel happier. And so it was sort of it's just the magic of post-production, editing, sound design, music, etc.
And what do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best music? Let me finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is, on any production, you're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works. And it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the combinations together to make a more successful production.
Absolutely.
I'll tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2, is that correct? And Aquaman, and Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying...
That'd be a test screening. So during our post-production of movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
And they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had, that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
No.
That's correct.
Sì.
And Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
What, if any, issues did you have with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Your Honor, we call Dr. Colburn next, but I know we have a preliminary matter that we need to deal with briefly, if we may approach.
Sure.
Mi scoccio per quelle 2 caccole nere, vabbè. mentre loro discutono, noi facciamo una cosa che lo so che ho già stampato, lo so che non si spreca il materiale, ma io lo faccio perché così non lo debbano fare gli altri, lo stampo anche di piatto e vediamo che cosa cambia. Nero è perché ha bruciato? No, il nero è perché il materiale con cui ho stampato prima di questo era il nero, quindi leggere impurità nell'estrusore che si sono poi manifestate a metà del primo layer, per cui nulla di grave, scoccia solo un po' esteticamente. Questo lo proviamo a stampare così. E in questo caso non mi serve il brim, ma andiamo con una normale skirt. 8 ore e 17. Per mezzanotte ce l'abbiamo. Però abbiamo solo supporto lì e tutto il resto senza supporto. Modo d'angolo non lo uso. Così stamperà meglio, però potrebbe non stampare bene questa parte qua. Vedete che un lato c'ha la scaletta mentre l'altro sarà piatto? Rinforzare la parte centrale no, ne stamperò anche un terzo, Sergio. E non è simmetrica la scritta safe, non posso farla scavata da parte a parte. Comunque, proviamo a vedere come viene così. EICS H, dammi V3 short, 8 ore e 17 minuti, let's go. La finisco sta bobina. Non devo fare un supporto per la parte sospesa? C'è. Caricatore 1 l'ho fatto, questo lo sto provando a stampare in un altro senso, quindi invece che stamparlo così, lo stampiamo così, dovrebbe venire molto 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 più resistente, adesso vi spiego perché, nel frattempo mettiamo la stampa. Allora, il materiale stampato in 3D, nel frattempo tengo un occhio per quando parlano perché qua stanno chiacchierando. Il materiale stampato 3D è un materiale Perché non hai fatto le scritte simmetriche? Perché si leggerebbe specchiato. Se da una parte c'è scritto safe, dall'altra ci sarebbe scritto EFAS. Il materiale centimetro cubo è 1,27? Comunque, il materiale della stampa 3D è anisotropico. Questo vuol dire che le sue proprietà meccaniche non sono le stesse in tutte le direzioni. Il metallo è un materiale isotropico, perché appunto il metallo, se io ho un cubo di metallo, se do una martellata così, così o così, non fa differenza. In questo caso, sì, fa molta differenza, perché la direzione con cui vengono stampati i layer cambia tantissimo le proprietà del materiale. Nello specifico, avete visto durante le martellate di prima che se io colpisco, i layer sono così. Se io colpisco in questo modo, sto comprimendo i layer su loro stessi, è super resistente in questo modo, è praticamente indistruttibile, cede prima da altre parti che così. Se lo colpisco così, come è successo, i layer io prima ho dato una martellata qua sopra e si è spaccato qua. Perché quando do un colpo, i layer cercano di fare questo e quindi si separano, si spaccano. Infatti non è che si è rotto, ma si è proprio separato. Se voi guardate, si è separato quasi perfettamente sul layer. Perché quando ha flesso questo pezzo, si è separato il layer. Lo stesso lo si può dire se io dessi una martellata qui sopra. Immaginate che qua sono tutti i layer organizzati così, quindi cederebbe sicuramente, e lo stesso discorso va fatto se colpisco in questo modo. Potrei creare una tensione che risulta nella spaccatura tra i layer. Ma in questo caso, se io lo stampo di piatto, quindi in poche parole, stamparlo come l'ho stampato io, dal basso verso l'alto così, se io lo stampo come ho fatto così, ho un caricatore estremamente resistente su questo asse, che è molto importante perché l'otturatore picchia qua dietro, quindi io posso anche sbattere l'otturatore e non spaccherò mai il caricatore che picchia qui. È molto resistente il dente su cui si aggancia il caricatore, per lo stesso motivo, ma non sono estremamente... No, non è vero, sono anche molto resistente sui colpi laterali, perché io il layer ce li ho che flettono su questa cosa qua, quindi sono molto resistente da questo lato e da questo lato, ma non sono resistente dall'alto verso il basso. E cos'altro vi ho detto? No, scherzavo, sono molto resistente in questo senso, poco resistente in questo senso, poco resistente in questo senso. Quindi se col caricatore infilato prendo una botta così, ho dei rischi di strappare. Se io lo stampo di piatto in questo modo, invece sono molto resistente così, su questo asse, meno resistente su questo asse, ma si tratta di un pezzo lungo, e meno resistente in questo asse, ma di nuovo si tratta di un pezzo lungo. Quindi in teoria dovrebbe essere molto 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 forte stamparlo in questo modo. Ovviamente converrebbe Foxy, ma cambierebbe il costo. Comunque, il prodotto è valido per me.
All right, ladies and gentlemen, I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15 minutes. Do not discuss the case and do not talk to anybody, okay?
Alla pausa fanno
Yes,
pure.
research. Sorry, that was the same thing. Take a break. All right. And if the doctor testifies, then is that WebEx? Okay, so I'll get that set up too while we take the break as well. All right? All right, we'll go ahead and take a break. Let's make it 10:50 to give them time to look at everything, okay? Thank you.
All right. Ok. Cos'è che volevo dirvi? Vi sta piacendo Squad? Mi sembra dai numeri di sì. Mi sembra che state apprezzando Squad e io lo apprezzo, anche parecchio. Mi sembra una buona alternativa finché aspettiamo che succeda qualcosa di concreto, no? No, santo. Sarebbe figo, ma no. Ci sta. No, dovrei probabilmente a Checo stamparmi delle forme e farlo per casting. Sarebbe figo farlo per cast, questa roba qua. Grazie, Invicti. Dovrei fare dei calchi di questa roba qua e castarlo dalla resina. In quel caso ho proprietà isotropiche. Sarebbe figo. Non l'ho mai fatto di castare... Solo che se faccio una mold poi devo veramente venderli perché se no non ci rientro dei costi. Dovrei farmelo stampare a resina da qualcuno in modo da avere una stampa con qualità spettacolare e poi da quello mi dovrei fare un calco. Fai un Kickstarter? Ma per sta roba, ma va se faccio un Kickstarter. Non ha tutto sto mercato una cosa del genere. Tra l'altro, se lo facessi a resina sarebbero da rivalutare tutte le misurazioni. Perché comunque la precisione... What? AICS. Dammi... Anzi, mi conviene... Dammi Mag... ICS... Hollow... Duplico... Questo volevo riempirlo invece. Ok, qui devo fargli l'estrusione. La facciamo su simmetrica 5 mm. Poi facciamo un draft 3, 4, 40 gradi. E lo facciamo anche di qua. Questo diventa un gruppo. E tutto il resto dovrebbe funzionare. C'è di nuovo un problema lassù. Perfetto. Va bene, va bene, va bene uguale. Questo dovrebbe essere quello stampato senza supporti da dietro. Cioè, ma non segue il processo oggi? È qui. What? Houston, we have a problem. Livelliamo il piatto di nuovo, va? Non era un espertone, era il capo della divisione film di Warner Bros. Che ha testimoniato che Amber Heard non la volevano comunque, indipendentemente da quello che ha detto Johnny Depp o Adam Waldman. Era una decisione del direttivo di rimuoverla per la mancanza di chimica con Jason Momoa. Ok. Sì, pare di sì, VRT. Processo in pausa 15 minuti, yes. Se volete vi tengo questa immagine qua. Per la felicità dell'esperta di lei. Espertissima comunque, è davvero competente. Ah! Con un dito, chat. Ditemi se non è very nice. Beh, cosa facciamo dopo? Qualche idea ce l'ho. E guardate come sta nella borsa. Dov'è il cellulare? Ce l'ho di là. Ah. Ah. Dopo, se trovo le chiavi... Le mie chiavi di casa... Valigione della Remington comprato su Amazon per 200 euro. Made in Italy. Potremmo fare questo. Che secondo me è pure più facile. No, mentivo, forse no. Beh, non deve essere un bananone, può essere tanto più piccolo. Può essere piccino. Anzi, non avrebbe senso fare il bananone. Potrebbe essere una roba così. Piccino, stretto, indispensabile. Mi preoccupa solo questo dente, perché io contavo di stamparlo così, questo, che aiuta con questo dente posteriore, ma questo anteriore potrebbe essere un problema. Specialmente se deve essere così piccolo per forza. Fammi vedere un po'. Sì. È bello, ma non ve lo faccio vedere. Se no mi tolgono l'home page che non ho. Non gliela fa. Più lento ancora.
All right. Yes, sir? Okay, approach. Ms. Myers.
Ah! Ancora? Minchia, oggi martellano, eh. Non ho scritto comunque. Non ci sono altre piattaforme meno restrittive di Twitch e YouTube? Sì, ma le guardano in 4 persone, non sono. Non ci puoi vivere su quelle. Fixer. È successo qualcosa di eclatante? Ma a parte il fatto che il direttore della divisione cinematografica di Warner Brothers ha detto che Amber ha perso il suo ruolo per la mancanza di intesa con Jason Momoa e non per le dichiarazioni né di Johnny né di Adam Waldman né di nessun altro, no, perché non apri un Reddit? I miei moderatori lo hanno già fatto ma non l'abbiamo ancora mai annunciato, però esiste il subreddit. Colpa mia, che se non l'abbiamo annunciato. Poi niente di eclatante, Matiz, soprattutto se appunto a parte quello nulla. No, stamattina hanno fatto quasi un'ora di motion to strike. Come mi sento per il 27? Onesto, non mi interessa tantissimo. Longa? Devo ammetterlo. Se parliamo dell'evasion. Non mi interessa molto e penso di parlare a nome di tutti, cioè anche per Frene e Canta. Bello che partecipiamo, però sta arrivando il torneo in un momento in cui Tarkov è tanto moscio dal punto di vista dell'intrattenimento, per cui sono contento che ci sia qualcosa, perlomeno c'è qualcosa, ma sapete, molto meno hype. Non per la mappa in generale, ma in generale perché non c'è niente di male secondo me a staccarsi ogni tanto dal gioco. Capisco l'insistenza di Evasion, però in questo momento il gioco è morto. Non è morto, cioè non prendete tutte le mie parole letterali in questo caso. Non è che è morto, ma è sicuramente in un momento di stallo rispetto ad altri momenti, ecco.
I'm just trying to get you on the big screen. We're waiting for the jury. Just give us a minute, okay, sir?
Thank you.
Questo è il medico che ha curato Johnny Depp. Hanno provato a ravvivarlo con gli eventi dei vendor. Il problema è che li hanno fatti troppo presto. O mi wipi la settimana finalità dell'evento, nessuno 100 miglia, o se no è inutile. Cioè adesso stanno palesemente allungando il brodo per arrivare fino a giugno. E stanno continuando questa narrativa del telefono rubato dagli scav, ma troppo lunga nel tempo. Per cui un conto se mi condensavi tutto in una settimana e io seguivo emozionato cosa stava succedendo, ma se ogni weekend sto tizio fa 4 passi mi rompo i coglioni.
Sir, if you could raise your right hand.
Mette le cuffie.
Do you swear affirm to tell the truth under penalty of law?
È live, non è una deposizione, questo tizio è live.
Your Honor, I would just object that Dr. Culver appears to have a stack of documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away and just testify from your memory, okay, sir? Thank you.
Thank you, Your Honor.
All right, your question?
Good morning, Dr. Culber.
Morning.
Could you please state your full name for the record?
David Allen Culber.
And what is your profession?
I'm a plastic and hand surgeon.
And how long have you been a plastic and hand surgeon?
Been in practice for 26 years.
Where do you currently work?
At Cedars-Sinai Medical Center.
How long have you worked there?
For the past 26 years.
Minchia.
Do you know the plaintiff in this action, Johnny Depp?
I do.
And how do you know Mr. Depp?
I had taken care of him when he had injured his hand.
When
Con
did
questo
Mr. Depp
penso che sia
become
lo
a
scacco
patient?
matto.
Sometime in March of 2015.
And what type of treatment did you provide to Mr. Depp?
He had a fracture of his finger with soft tissue loss. And so we reconstructed his finger.
When did you perform the first surgery on Mr. Depp's finger?
I believe it was around March 20th of 2015.
And what was involved in that surgery, just briefly?
Debriding the vitalized tissue, putting a hypothermic skin graft, restore some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced distal phalanx fracture.
What was the state of Mr. Depp's hand immediately after that surgery?
Eh?
I'm sorry, I think the audio cut out a little bit. Could you please repeat your answer?
It was injured and had soft tissue loss and a fracture of his distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed that surgery?
It was a plaster splint.
And can you please describe to the jury what
Niente, morta la
a plaster
connessione.
splint would look like?
So it's like a cast, but you don't
Scusa un
want
attimo, ti rispondo per iscritto, Usa.
because of swelling after surgery. So, I believe in Mr. Depp's case, it was like the two fingers. I think the third finger was the one that was operated on. So these two fingers, the third and fourth finger, are together, and it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his third and fourth fingers because of the bulkiness of the splint. Typically, post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be. He had his index finger free and his thumb free, but the other fingers were probably not being able to move.
Quando? Ma è ufficiale? Poco fa. Testimonianza diretta del direttore della divisione film di Warner Bros.
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office.
How long did you ultimately treat Mr. Depp for his hand injury?
For several months.
And why was that?
It was a bad injury.
Questa settimana, Pixel.
Required a few more little office procedures to clean up the tissue. He had an infection as a result of the injury, so he had to be on antibiotics for some time until it finally completely healed.
E penso che lui smentirà gli espertoni di ieri.
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same. Around 2015.
Right. Thank you, Dr. Colbert.
All right, cross-examination.
Sai che non lo so, Nico.
Good morning, Dr. Colbert. So you said that this plaster splint was put on after surgery on March 20th.
What? What? Rottenborn ha rotto tutto? Audio. No sound. Niente. Allora dovrei essere tutti e 3 i giorni, Devi. Mi cerco un'altra diretta mentre questa si fixa.
Just as hard as any other cast, correct? And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
Ho paura, blocco sempre perché ho paura che siano prove che fanno vedere dita rotte, robe del genere.
Permission to publish?
Yes, sir.
Okay.
Dr. Colbert, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions to the witness.
They're in evidence. Thank you.
Michelle, if you could go back up to that, stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage
Ovviamente
to Ms.
no.
Heard's closet on March 23rd, 2015?
Ma che prove hai che sia stato lui?
Overrule.
I mean, he had his other.
Il mio microfono, questo? È un Acon.
No further questions. Thank you.
All right.
QM14 USB. Ah, fanno poche domande oggi, eh? Fanno pochissime domande,
Dr.
sanno che
Colbert,
hanno 3
how many
ore.
fingers were in the plaster portion of Mr. Depp's cast?
I believe 2, 3, at least 2 were, and the third one and the fourth one.
And why did you
Di nuovo? Di nuovo?
Because it's not fully, plaster doesn't go around the entire hand because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely.
Vero Zenese.
So there's soft spots to it.
and where are those soft spots located again?
Usually we put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have damaged the cast.
Did you ever notice any damage to Mr. Depp's face when you treated him after the surgery?
I don't recall. But nothing that comes to mind.
Sei un cretino. Cartonato su
Could
mettere.
Mr. Depp form a fist with the cast on?
No.
No further questions. Thank you, Dr. Kohler.
All right. Thank you, sir. That concludes your testimony. Thank you. All right. Your next witness.
Oggi vanno a martello, ragazzi.
Plaintiff calls Richard Marks, Your Honor.
All right. Mr. Marks. Sorry, just a reminder that you're... Move it. Hold on. I'll move it. Just give us a second on the TV. No, sir, you've already... Just a reminder that you're still under oath, okay, sir?
Filippo, non cambia niente se ti salvi o no. Dopo lo faccio. Ne ho tantissime di richieste. Devo andare a cercare la tua. Tanto, Paperinic. Ti sta piacendo, sono contento. È sempre avvocatessa di Depp. Ma lo richiamano? Questo ho già parlato, non mi ricordo. Sì, sì, aveva già parlato. Aveva già
Welcome back,
parlato.
Mr. Marks.
Grazie, Filippo.
You've testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and I'm a full-time entertainment transactional attorney. I make deals.
Questo aveva già parlato, è un deal maker di Hollywood, tosto, riconosce la correlazione accuse danno per Depp.
Negotiating and then making sure
Aveva
the
già parlato.
contracts reflect the deals. And I'm very much distinguished from the other side's expert who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
Lo chiamano per smontare l'esperta di
And are you
ieri.
familiar with the testimony of Catherine Arnold in this matter?
Catherine Arnold,
Have you been asked to analyze that testimony?
l'esperta di
and provide
ieri.
Opinions in response?
Yes.
And generally, what are those opinions?
Well, my opinions are that she's very slick and smooth, but she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
Sono d'accordo.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those opinions?
Absolutely not.
Why not, sir?
Well, what we're dealing with in this case is a test option agreement. And that's an agreement, it's a multi-picture agreement, and it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors the next morning at 9, and you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one. They're the Stars Born moment, if you will. They get the part. Normally, their salary is inflated from their normal salary, because now they're going to play a character that could go on for 4 movies. In this case, Ms. Heard's first salary when she got the part was $450,000. If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation. All they had was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times to get to the $1 million. These are large bumps, if you will. If an actor is on a series, say, they go, and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option.
La differenza della competenza e del calibro delle persone che porta Johnny sullo stand rispetto a Amber è abissale.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role. Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them, and then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, you get to $4 million. These are unheard of bumps if you're going on a normal career and trying to increase your salary by increments.
In your experience, what is customary for negotiations of multi-picture deals?
Well, I think what happened in this case was customary for negotiation of multi-picture deals.
No, lui non è d'accordo con la testimonianza dell'esperta di ieri, l'ultima che ha parlato, Catherine Arnold.
Success. The reason you go from the first Justice League movie where Miss Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Miss Arnold was referring to, a renegotiation, if you will, for the third movie. Instead of doubling her salary, Miss Arnold said it would only be fair to quadruple her salary.
Quindi lui sta dicendo che il salario previsto per Amber nei film successivi comprendeva già la rinegoziazione eventuale. Era già il miglior contratto che le potevano fare, in poche parole.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Perché è 4 volte quello che ha preso
As I
nel primo?
said, that would now be, after a healthy first payday, it's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio,
Minchia, veramente,
said
Nico.
it doesn't happen. They're not going to do it. Miss Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman. We don't know what his contract, the state of it was when you got to Aquaman 2, and she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period, when you've only got one option left,
No, Mickey, non è scontato per
want
niente.
that star in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take.
Certo.
And unfortunately, Ms. Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts. We don't know anything except she's asking you just to believe her.
Dai tracker per sta roba no.
What I refer to as a professional expert.
Io trovo che tutte le testimonianze che porta Depp siano interessanti, cioè è proprio interessante ascoltarle queste persone.
Would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address some of the components of that one by one with you, Mr. Marks. Are you familiar with her testimony that Ms. Heard would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with, and I think there is reasons to negotiate.
Esatto, è proprio una maggiore compostezza, è molto molto bello vederli scimmia. Io questo lo ascolterei 3 ore.
Or if it was a $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the independent passion project, where they'll defer their salary and almost take nothing to work, just SAG minimum, to assume that she'd get 4 or 5 more movies at this, her last fantasy quote, would be to assume that those are also those type of movies, playing another character.
Esatto.
And Ms. Arnold says that Ms. Heard's breakout moment,
ha una tastiera con le sillabe, ha tipo 10 tasti, fa tutte shortcut per fare le sillabe, Nico.
Those moments
è tipo una pianola.
Happen to supporting cast. But if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in, to take advantage of this hot star and to sign them up.
Esatto,
we have, from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Miss Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the million Miss Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor. He's been in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones. It's not a comparable.
Your Honor, I'm unresponsive to.
All right, I'll sustain the objection. Next question.
Mr. Marks, we'll get to some of those issues in a moment, but I want to take you back for a second. I believe you testified a few minutes ago that your
Sono d'accordo, il successo di Aquaman è dovuto alla celebrità di Jason Momoa, sono completamente d'accordo con te.
Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a 4th option for Aquaman 3 or another movies where Mira appears, that character, and they've agreed to double the salary again. So it's in success, and that assumes that they recast.
Assolutamente, Giubbins, è vero.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree
Anche
with
quella è una
that
stronzata.
opinion?
No.
Why not?
Again, this is a business of personalities. We didn't, after the breakout moment that Ms. Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Ms. Heard during that 16-month period before
È una questione di personalità, di quanto piace alla gente, è materiale, ma è quello che è.
We didn't see those endorsements coming to her. We didn't. What Ms. Arnold shows you is these non-comparable actors. They had endorsement deals, but
Jason
she doesn't
Momoa,
show you.
nonostante non mi stia simpatico al 100% per tante cose, è però un cool dude, cioè è un tizio che piace a tanti, che si fa piacere, amichevole, simpatico, bel tipo, è un modello per tanti aspetti. Non è se non c'era sto processo, io non sapevo manco chi era lei.
My primary question is what happened in the 16 months, even if you believe
davvero
statements in the Daily Mail.
Io mi ricordo esattamente il trailer di Aquaman. Mi ricordo che avevo visto questa qua e non sapevo chi fosse.
Ms. Heard would have made $1 million an episode in a couple of streaming series following her A Star is Born moment?
Yes, I heard it. I have an opinion.
What's your opinion?
Well,
non è l'attore migliore, ma è super popolare, scimmia.
This is a major coup. Amber Heard got
The Rock con le branchie.
She tested for it. She could have been the other 19 actors
tra le rughe e la
whoever else tested.
Sai che mi sa che questo è esattamente il suo scalpo?
And she got her salary doubled for
Sai che mi sa che questa era la sua vecchia linea dei capelli? Pazzesco.
Now, Ms. Arnold wants you to believe that $1 million would translate into, she'd get that for each episode of the series.
Ti confesso che mi sono cercato degli spezzoni di Aquaman per vedere come recita. Super blanda, sembra una supereroina dalla serie TV The Flash.
2018 before spring of 2020, she got a series. It was 8 episodes and it was $200,000 an episode. And Miss Arnold is from somewhere in a glib way saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series.
Bellissima testimonianza comunque.
And again, in those 16 months, there were no offers for series at $1 million an episode. In fact, her only series is the $200,000. And if you look at her resume, the series that Ms. Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Ms. Arnold, and somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode, if you're to believe that, Jason Momoa has had a series with 78 episodes.
78 episodi contro 8.
With 21 episodes, with 18 episodes, with 21 episodes.
Anche secondo me, Giubbin,
Again, there's not...
gli avvocati di lei adesso devono tenersi tutto il tempo del mondo per andare contro Kate Moss, Dr. Curry e Depp. Tutti gli altri non gli interessano, devono tenersi le ore di tempo per loro tre alla fine.
Part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played.
Hanno perso un sacco di tempo con degli esperti del cazzo.
They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not. They might say we're not exercising.
Ma è l'avvocato che gli lascia il tempo di rispondere. L'avvocato potrebbe anche tagliare e andare alla prossima domanda.
But it's not a contract until the studio exercises the option, and they don't have to.
What's the alternative to an option agreement?
Quanti posti sta scrivendo lei oggi?
Agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So most contracts are guaranteed. You're hired to play the role. In an option agreement, once they exercise the option, for that movie, it becomes a guaranteed contract.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and then subsequently rehired?
I heard that testimony.
Is that consistent with your experience in the film industry in connection with these multi-option contracts?
No.
Why not?
Again, studios don't do things they don't have to do. As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring, and in my experience, in almost 5 decades in the business, doing this type of work, not talking about it, not consulting.
Dissato la testimonianza.
You know, I heard Ms. Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, you know, it's not a contract till they option it, and
blastata quella di ieri.
And at that point, it's a guaranteed contract, and then different rules apply to it.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath basically saying...
Secondo me sta facendo scarabocchi per far finta di avere una controrisposta.
Objection, Your Honor, hearsay.
I think it was an in-court statement this morning, I believe, Your Honor. That's fine.
It's the same hearsay that you were... It's hearsay like yesterday. I mean, it's hearsay.
I'll overrule the objection. Go ahead.
Thank you.
I didn't hear.
Go ahead, sir.
Overruled. You can continue, Mr. Brooks.
I was surprised to hear Mr. Hamada say that they talked about chemistry. That would normally be behind closed doors because it can't help your relationship with the actor. You're either going to exercise or not. And that was quite a bit of candor from someone at his level.
Sono d'accordo.
And so, therefore, I take it at face value. I think he felt that he was under oath and he was telling the truth, but it wouldn't
Objection,
be...
Your Honor, is...
Questa è speculation. Questa è speculation.
Mr. Marks, are there circumstances
sono
where a
d'accordo con lui.
studio would be more likely to say something about not using an actor again in a franchise?
Yes.
What are those circumstances?
Once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor but not play them, pay or play them. And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not normal.
Is that circumstance different from Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't, she's not. Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we'd still have a right to recast and not make the movie. We just have to pay her salary.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine?
I heard that.
And what's your opinion of those actors
I disagree.
as comparables for Ms. Heard?
Even Ms. Heard's agent, Jessica Kay, said that 4 of those actors weren't
Objection, Your Honor,
comparable.
hearsay.
I believe same response, Your Honor, that it was in testimony that was played in court earlier.
Testimony, già,
I mean,
overruled.
That's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
Or you can cross-examine, overrule.
Overruled.
Overruled. You may continue, Mr. Marks.
Again, they are not comparable. Jason Momoa was Aquaman. Chris Pine was Captain Kirk. Gal Gadot was Wonder Woman. Zendaya has been working on Disney Channel since she was 13. She's in all the Spider-Man movies. She goes by one name. Ana de Armas, when she was in a movie that they call, her breakout, it was as a nude poster. She's been in an ensemble piece, Knives Out. These are not comparables. Now, Ms. Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career, but she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those building blocks. She just she set him up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables. And she built like this house of cards on nothing. She showed us with her words the beautiful clothing that the emperor was wearing, but we could see, if you know the business,
Objection, Your Honor.
that he wasn't.
Beyond the scope of the question.
All right, I'll sustain the objection. Next question.
Okay. You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to
No, era proprio usato come figura retorica, Pino. Non la serie, ma figura retorica.
Negotiate his salary for significant increases in bonus?
Yes.
What's your response to that opinion?
Again, I don't have comparable franchise experience to Ms. Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable. And you can say the words, but I saw nothing from Miss Arnold to back it up, something to build on, which, if she was a negotiator in the trench, the studio negotiator would say, okay, so show us, where's the comps? Let's talk numbers, because ultimately that's where we have to get to, not just because you say it's so. We just don't believe you. You've got to show us.
In your experience in the industry, what factors influence the negotiation of
Penso che siano le sferzate
film
finali, Ness.
agreement with an actor?
Well, I mean, first it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of what the deal should be is past earnings, precedent, comps. You also look at the budget of the movie, what it can bear, because if Jason Momoa's comp is $10 million, but the budget's $10 million, obviously he has another price for that movie. But the best predictor of future earnings is past earnings. And I didn't see any Miss Arnold talk about past earnings at all, except the earnings in this rarefied superhero 4-picture deal where instead of incremental increases, which you normally see, it was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15, small percentage raises. They don't get multiples. They get the multiples if it's a success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the previous payday.
Sì.
What's the significance of the timing of the Waldman statements to the opportunities Ms. Arnold claims Ms. Heard lost?
Well, the argument, as I understand it, is that Ms. Arnold says that Ms. Heard lost all these opportunities because of those losses were caused by Adam Waldman's statements 16 months later.
Esatto, Marcello, esatto. Quest'uomo è interessante. Cioè, è interessante quello che dice: percepisco la sua esperienza, percepisco la sua cultura e ne voglio sapere di più. Diverso invece dagli esperti che invece capivo che mi stavano fregando. Cioè, capivo che è proprio una differenza di credibilità. Un uomo del genere immagino che ne ha viste di tutti i colori e voglio sapere quello che ha da dire. Il Dr. Brown di ieri, il pazzo di ieri, lo vedo che è un cazzaro, non me ne frega niente di perdere tempo con quello che ha da dire. È un cazzaro. Supercazzole, cioè non sono qui per le supercazzole. Queste non sono supercazzole, ma sono argomenti concreti di una persona che ha esperienza sul campo e sono molto interessato a seguirli. Così come sono stato delusissimo dalla performance dell'esperto che ha programmato Unix, cioè fa tutta quella premessa per poi fare un'analisi del cazzo.
Mr. Marks, what's your overall assessment of Ms. Arnold's opinions in this case?
My overall assessment of her opinions is that they're not worth the paper they're not written on. She knows something about our business, but not about negotiating deals. She may have gotten someone at the Endeavor office to
Non
breach
vale la carta su
confidentiality,
cui è scritta.
but she never laid out the building blocks.
Excuse me, there's an objection. You have to stop talking, Mr. Marks. Thank you. Beyond the scope.
Yeah, Mr. Marks, can you just limit your testimony to your opinion about
Okay.
Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background, she doesn't have the day-to-day knowledge, and her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved. And again, she was constructing a Jenga without the bottom pieces.
Non arrivi al livello che è lui su una carriera di 5 decenni se non sei un mostro sacro in quello che fai. Qua non è dire sono esperto da 30 anni, qua lui è nel cuore dei trattati di miliardi, cioè di milioni di dollari da 50 anni. È la persona di cui la gente si fida per quei contratti.
Good morning.
So you agree that studios use comps to negotiate deals, correct, with actors?
Sometimes they do.
Okay. And you have an issue with the comps that Ms. Arnold used, correct? As you testified to.
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, I mean, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary history as comps.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to...
That's not my question. Are you offering a different set of comparators than what Ms. Arnold used?
I'm not here offering comparators. I'm saying what she offered were not comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms. Heard's comparisons are where you
That
look.
was my question. Motion to strike after the...
Oh,
no.
all right, we'll strike after that. Just answer the questions, Mr. Marks. Thank you.
Now, you're a deal maker, correct?
Yes.
What actors have you negotiated for in superhero movies?
Vai.
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently a deal for Paul Rudd and Will Ferrell on an Apple series. Billy Crudup on an Apple series. Those are the recent talent deals.
What actors have you negotiated for a superhero movie?
As I sit here now, I can't remember a superhero movie that I've negotiated. I've certainly negotiated over my career franchise movies and fantasy movies.
Your Honor, so it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a fantasy.
Okay, so no, correct. Your answer
Okay,
is no.
all right. So as I sit here, I can't think of a Marvel type superhero movie that I've negotiated, although I know there's one or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were pro-offered, such as he didn't have an option. His options were out. What he was earning and what he renegotiated to, and he is Aquaman man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If you tell me that, I haven't seen his contract and I haven't heard any testimony under oath that that's where the leap was.
Now, Ms. Heard's contract.
Did he get more? Did they get more options for when they made that leap? Did they get more options?
Ms. Heard's contract was a talent option contract, correct?
Yes.
Okay. And you agree that for if there's an Aquaman 3, Ms. Heard would have an option to receive $4 million, correct, for the movie?
Well, actually, you would language it, Warner Brothers would have the option to engage her.
And if they engaged her, she would receive $4 million, correct?
Yes.
She doesn't have the option to refuse. They have the option to engage her.
And she would receive $4 million, correct?
Yes, $4 million.
Would you agree that the money Amber was making on Aquaman 2 or 3 would be her market rate for future studio movies?
I would think it would be her rate for
franchise
future
movie
studio superhero movies.
Sono d'accordo.
But not necessarily studio movies that aren't superheroes. That could be standalone. That could be other type of studio movies.
But for studio superhero movies, it would be $4 million, correct?
If I was Ms. Heard's agent, that's where I would start. Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
No.
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that movie, correct?
I believe so.
You would agree that for all of the actors Ms. Arnold listed as comparables, their career trajectory went up after their breakthrough, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa.
C'era la mamma di Aquaman più protagonista, non l'ho visto, non posso parlare.
As did Miss Arnold when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
Vai.
As I sit here now, I haven't been asked to opine on that, but there are lots of supporting characters in movies that don't appear in the next movie.
Non c'è Rhodey in Iron Man 2.
In a breakthrough movie in a superhero movie, can you identify any
La mamma era
actress
solo
who's
Nicole
not gotten
Kidman.
another studio movie after that?
Well, after Miss Heard's breakthrough in 2018, she did get Aquaman 2.
Aquaman 2 was already, she already had the option for Aquaman 2,
all right,
correct?
so she did. Miss Heard did not get any movies after 2018, long before the Adam Waldman statements.
Other than Ms. Heard, can you identify any actor or actress who's not gotten another studio movie after their breakthrough in a superhero movie?
As I sit here now, I haven't been asked to research that, and I can't. That would be a normal thing.
And you're not providing an alternative number for Ms. Heard's damages, correct, for the jury?
Correct. I'm not providing an alternative number. I think she's been more than adequately paid.
I'd move to strike after no, I've not been provided another number.
Poi c'è stato anche Hulk.
That's all. I mean, my question was you're not providing.
L'aiutante di Momoa è William Dafoe, lo sapevo, ma so anche che Hulk è passato da essere Norton a essere Edward Norton a... Non mi ricordo come si chiama l'attore nuovo, però insomma non è una cosa mai sentita di ricastare gente.
All right, no further questions.
All right. Redirect.
Mark Raffalo, grazie. Mi sfuggiva.
Mr. Marks, in response to some questions from Mr. Lederhaft, you were discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I've had such a long career that
In questo momento gli avvocati di Johnny hanno tutto per le palle perché possono permettersi di perdere tempo con queste domande più discorsive. Loro devono tagliare dritto.
That was produced, is Coming to America, the original, is that a fantasy movie? The Golden Child, is that a fantasy movie? Yeah, and by the way, I may have negotiated contracts, and ultimately the film wasn't made. But as I sit here now, those are the only ones that come to pass. If I was looking at my resume or going through my files, I might think of others, but there isn't a deal that I haven't made.
And I think you also testified in response to Mr. Nadelhoff's questions that you have negotiated some deals for Chris Pratt and Paul Rudd. Do you recall that testimony?
Yes, these are for a streaming series.
Do you happen to know if both of those actors have played Marvel superheroes?
I believe they have, but don't quote me because, that's not my genre.
Okay. No further questions, Your Honor.
All right. Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can leave, okay?
Thank you very much.
Thank you. All right. Your next witness.
Per il cast di Katie Holmes, bravissimo. Abbiamo poi anche, mi sta sfuggendo, X-Men che hanno ricastato tutti. Non mi viene, aiuto.
You've testified previously, correct, Mr. Spindler? All right. Just a reminder that you're still under oath, okay, sir? Yes. All right, thank you.
No, Hulk, attenzione, forse questo non lo sapete, ma l'Hulk di Edward Norton è lo stesso di Mark Ruffalo.
Good morning. Can you remind the jury who you are and what you do?
Yes, I'm Michael Spindler. I'm a forensic accountant. I'm a CPA, a certified fraud examiner, amongst some other certifications. I'm with B. Riley Advisory Services, a national firm that does forensic accounting, bankruptcy and restructuring work, and business valuations and appraisals. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Do you understand that Ms. Arnold testified that Ms. Heard has suffered economic damages?
E ora smontano pure I danni di ieri.
Made by Mr. Waldman?
Yes, I do.
Lo spessore di queste dichiarazioni.
I do.
E il secondo film è uscito dopo Iron Man, Same.
All right.
La differenza tra il portare un esperto e una persona che invece è responsabile per queste cose è lampante. Cioè gli avvocati di lei hanno sprecato centinaia di migliaia di dollari per chiamare degli esperti della fuffa. Molto interessanti, Kevo. Molto, molto, molto interessanti oggi. Esatto, senza fronzoli, perché non devono dimostrare nulla. Nessuno. Questi non devono dimostrare niente. No, non ho visto, Matiz. Adesso è successo?
Thank you, Mr. All right. Your next witness.
Plaintiff calls Michael Spindler.
Michael Spindler.
Plaintiff calls Michael Spindler.
Michael Spindler.
La differenza di quando sei una persona stimata nel settore, eh? La differenza di quando sei una persona stimata nel settore.
Thanks, Mr. Spindler. Now, you indicated that you had listened to Ms. Arnold, and she testified on behalf of Ms. Heard relative to economic damages. Have you formed an opinion as to the testimony and opinion rendered by Ms. Arnold?
Yes, I have.
And what's that opinion?
It is not adequately supported, and it is unreasonable.
Ma va.
There were multiple elements to that analysis, both damages related to her film career and to endorsements. Have you analyzed both those issues?
Yes, I have.
What is your opinion of the claims that have been asserted relative to the film career and endorsements?
Okay, well, first of all, with respect to her damages calculation, there was no calculation per se. She initially looked at these comparable actors and seemed to use that as a basis for numbers. She didn't provide the underlying calculation. She didn't provide underlying support. And then it appeared as though in her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those numbers come from. And she still, to some extent, appears to be using some kind of comparable analysis.
All right. What is the type of analysis that you think is appropriate here?
Well, I think, and as you heard from the last witness, I think that something that is anchored in facts, taking a look at historical compensation as a basis for anticipating future compensation.
Had you looked at Ms. Heard's prior compensation?
Yes, I have. I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
Okay.
Well, once again, you want an analysis that's anchored in fact. I don't believe that Ms. Arnold has done that in her analysis. So here we've got some actual data, we've got some historical compensation, and as the last witness mentioned, that often provides somewhat of a basis for future anticipated earnings. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to look at a renegotiated salary for Aquaman 2 and then use that as a basis for future compensation, that being the new kind of base, if you will.
All right. Were there any years in particular that you focused on?
Stanno andando come treni, per cui non so dirti, scimmia.
As to Ms. Arnold's testimony?
In terms of the historical compensation?
Yes.
Well, for 2013 through 2019 in total, her compensation was around $10 million for all those years combined. In 2019, the last of those years, her compensation was somewhere between about $2.6 million and $3 million. Now, that's a good year. That's known as a clean year.
What do you mean by a clean year?
Well, for example, 2019, you had Aquaman was released in December of 2018, and that was a successful film. So in 2019, you've got the benefit of that kind of success, and you also don't have any potential impact from the alleged defamatory Waldman statements that...
È un'anomalia statistica.
So 2019 is clean of all that.
Verso le 18:30 di solito.
What did you understand Ms. Arnold's methodology to be?
Her methodology initially appeared to be based on these comparable actors that she had identified, and theoretically, the compensation that they earned.
Non è l'esperto di metadata, questo è un analista forense di danni.
What is your opinion of that methodology from an accounting perspective?
Un contabile analista, un contabile forense.
Unsupported. There are no numbers, there's no data that she provided and support for that.
What methodology did you understand Ms. Arnold to adopt at trial?
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damages.
Comunque è incredibile
still a little bit
quanto abbiano le gambe corte le cazzate, veramente.
There are 4 basic components that she was looking at, and we can go through those in any order you wish.
All right. With respect to the television series portion of her analysis, what do you understand that methodology to be?
Okay.
Objection, Your Honor. May we approach?
All right.
No, ma la differenza tra il portare un testimone esperto pagato per dire quello che vuoi tu contro quella di portare un esperto che ha una domanda, ti risponde subito boom con la sua opinione genuina, visibilmente genuina. Che cazzo vuoi dire? Miss Arnold è l'esperta di ieri che ha parlato del... era talent publicist analyst esperta, quindi l'esperta di talent che ha testimoniato in più di 100 casi, ma il 50% della sua professione è testimoniare. Per cui quella è la carta jolly che chiamano in diversi processi per portare acqua al proprio mulino. Esperta di gossip, sì. Detto in maniera più diretta, era l'esperta di gossip, assolutamente. Ma da tutta questa cosa, smontare i ciarlatani, sai cosa? Noti proprio una differenza di calibro tra le persone che portano. Cioè, Amber Heard ha toccato il paradiso con un dito con Johnny Depp, nel senso che va bene, al di là delle cose, delle droghe, quello che vuoi, ma è un ceto sociale diverso, è una community diversa, è troppo palese da questo intero processo quanto poco lei sapesse di quello che succede veramente ai livelli di Johnny Depp. Cioè, è un altro mondo, è un altro layer, è un altro livello. Non so non so se riesco a essere chiaro in quello che voglio dire, ma è un altro paio di maniche. Cioè, non si parla con lo stesso linguaggio, è un altro linguaggio completamente. Ha toccato anche di... Stessa cosa, sì, stessa cosa. Cioè, ma immaginate come sarebbe andata se fosse stata una causa contro Elon Musk. Assolutamente, Armstrong. In un caso come il suo, dove hai pochissime prove dalla tua, è normale che sia gli avvocati che tu vai a cercare cose che possono darti ragione, e se la ragione non ce l'hai, devi per forza pagare qualcuno per dartela. Senza contare che non voglio neanche dare completamente la colpa agli esperti, tra virgolette, perché comunque gli esperti hanno fatto il loro lavoro, ovvero hanno dato una testimonianza in base a quello che gli è stato presentato dagli avvocati. Dal momento che gli avvocati gli hanno presentato quello che volevano loro, capite che lascia un po' il tempo che trova. Ma se non hai ragione non fai una controcausa, no? Questa donna ha dimostrato di avere una faccia da culo, più culo del culo, e non... cioè, la controcausa secondo me fa parte della charade, fa parte della messa in scena di essere innocente e dalla parte della ragione. Il fare la controcausa lo fai per difendere l'immagine, secondo me. Lo fai per pararti il culo. Giubins, il fatto è che sono professionisti in quello, cioè loro sono professionisti nel testimoniare. Le persone che hanno parlato sono testimoni professionisti.
The earnings from television shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes, during
Esatto,
2019 she entered into a contract.
Perché è fondamentalmente narcisista e non è in grado di vedere i propri errori, secondo me.
At $200,000 per episode.
Cozzeno, grazie del Prime. E gonfia Steve Fleck.
Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000. Then the first Aquaman was $1 million base fee. Then $2 million for Aquaman 2, and presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Esatto, Klaus.
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result. So if you take a look at, for example,
Esatto, Allanon.
The analysis that Ms. Arnold did, it didn't appear to be...
Let's just look at the analysis that you're doing. What you said, I think, is you wanted them anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
Chiuso. Vediamo un po' cosa hanno da dire, va, gli avvocati di lei.
Hello again, Mr. Spindler.
Cacco matto. Quante persone stanno guardando la live? 850.000 persone, siamo prossimi al 1.000.000 di spettatori. Solo su questo canale.
Do you agree that we can both be on the same page what I'm referring to when I say that?
That's fine. You can
Seguitelo oggi, Capt, perché è pieno di roba importante.
Can we approach?
Ok.
Stanno smontando testimone per esperto per esperto. Un milione qui su Twitch, Serge. 2 milioni di spettatori totali, saranno, penso, capace che nel mondo, considerato televisione e tutto, ci siano 5 milioni di spettatori simultanei per questa roba qua. Io mi sa che chiedo un rinforzo fast food, ragazzi, perché mi sa che il problema che ho avuto... Oh, tra l'altro, avete idee su che cosa possa essermi successo stanotte per il mal di testa? Può essere che sto mangiando, che ho mangiato poco, può essere che ho stremato troppo, troppe ore davanti al computer.
So, Mr. Spindler, when I refer to the Depp-Waldman statements, you understand me to be referring to the statements in Ms. Heard's counterclaim against Mr. Depp, correct?
I'll understand that, yes.
Now, you're here to provide a rebuttal opinion to Miss Arnold's part of Miss Arnold's testimony.
Può essere. No,
correct.
Qua.
You're not providing an opinion on whether Miss Heard saw Mr. Depp, correct?
That is true.
You're not offering an opinion as
Quanto bevo al giorno?
underlying facts.
Ho bevuto
Whether Mr. Depp was
solo
being
bibite.
correct?
Forse quello. Era 2 o 3 giorni che
You're not
bevevo
offering an opinion as to the magnitude
bibite.
of damages
Quindi può essere
believe
quello?
Miss Heard may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Miss Arnold has said, correct?
That's correct.
Quello?
And you said that you want your analysis to be accurate in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one
Per 3
period
giorni ho
isn't
bevuto
necessarily
esclusivamente
reflective of what
bevande.
he or she may earn in future periods, correct?
Correct.
And that's because
there can
an
be some
increase in the
variability.
number of roles,
Yes.
an increase in the
Capisco,
number of
Alan.
roles may lead to greater income, correct?
I'm sorry, could you repeat that? I was speaking, I didn't hear.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income.
Veleno, senti,
The number of
non
roles. or the
fumo,
particular
bevo
project
pochissimo
itself.
dammi un
Sure,
veleno.
getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
It depends.
what Ms. Heard earned from, say, 2013 to 2019 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from 2013 to 2019, in terms of earnings and star power, that Ms. Heard's
Ieri ho
career
anche bevuto la
trajectory was on
Monster,
the
sì,
upside,
Ale.
correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd
Ieri
agree
ho
that
anche
that was
bevuto
as
la
a result
Monster.
of getting more lucrative roles, right?
No,
Yes.
no, dolore è solo qui,
Now,
fortissimo.
you're not a causation expert, right? You're just a damages expert.
That's correct.
So you're not testifying as to whether the Depp-Waldman statements caused her to lose.
Ma non è quello che ha detto.
Correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for roles that she otherwise would have been considered considered for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the Depp-Waldman statements, correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
Va bene, Matti.
That was not part of my work.
Va bene, vado a
And
prendermi
you
una
don't have
bottiglia
an opinion
d'acqua.
on the impact that additional exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never served as an expert witness before to calculate damages based on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified thereto.
And there's never been an instance in which you have served as an expert witness in a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact the Depp-Waldman statements by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
You're correct. That's other experts.
Can we approach
No
her?
further questions. Thank you.
All right.
For you.
Okay.
All right, thank you, Mr. Spindler. You can have a seat in the courtroom, or
Thank you,
you're free to
everyone.
go. Thank you. All right, your next witness.
Plaintiff calls Doug Banya, Your Honor.
Okay. Can you spell the last name for me?
B-A-N-I-A.
Thank you.
Non dovevo bere l'acqua? Cos'è, Beppe? È acqua con un goccio di limone. No, è acqua con un goccio di limone, chat. La lasciamo qui, l'acqua troppo fredda. Madonna, ma sembra un relitto umano, cioè non ce n'è una che... Lui è?
So you can,
L'ho già visto? Aiutatemi, l'ho già visto lui?
so just a reminder that you're still under oath, okay, sir?
Hai di nuovo l'esperto di ieri. Lui è?
Good afternoon, Mr. Banya.
Good afternoon.
No, chi è?
Can you briefly reintroduce yourself to the jury, please?
Yes, hi, Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide litigation support in infringement and defamation cases, as I'm doing today. And I use internet and social media analytics in both of those services.
Lui è l'esperto analista di Google.
The jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes.
Were you asked to analyze their testimony and provide opinions in response?
Yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
Questo smonta il discorso degli hashtag. Lui è l'analista Google.
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Ms. Arnold came up with are not comparable with Ms. Heard. And then thirdly, Mr. Schnell and Ms. Arnold both failed to provide any evidence of a causation as it relates to the Waldman statements causing any economic harm to Ms. Heard.
Let's dig into those opinions a little bit. You're familiar with the testimony of Mr. Schnell that there are more than 2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative.
Lui lavora per Google
towards Ms.
Analytics.
Heard.
Comunque,
Those
Gennaro.
hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and a hashtag, we just don't like you, Amber. So then he used those hashtags and he searched through, using the Twitter API, searched through various tweets and then came up with any tweets that were using those hashtags.
Did you conduct an analysis of those tweets?
Yes, I was given that exact, the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is, you know, were these tweets, did they contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the Waldman statements are?
So my understanding is there's three Waldman statements that were published in the Daily Mail. The Daily Mail is a UK tabloid, and Mr. Arnold was quoted in three of those articles, and those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may I approach?
Yes. Did you show counsel? All right, so 1293 will just be marked for identification as demonstrative and can be published to the jury.
Mr. Banya, can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data. There are tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed. So obviously, if these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations, and for me, there were red flags that I made note of, and then I just continued with my analysis.
What other work have you performed in connection with forming your opinions about the purportedly negative tweets?
Yeah, so now I realize that 35% are irrelevant and 2%, you know, only happened during this important period. I just continue to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Quindi ha rifatto lui stesso l'analisi, ho capito bene? Ha ripreso i dati lui stesso?
I'll give you time to look at it, sir. All right, plaintiffs. Microphone, I'm sorry.
No objection as a demonstrative.
Okay. All right. Plaintiffs Exhibit 1294 will be marked for identification as a demonstrative and will be published to the jury.
Thank you, Your Honor. Mr. Banya, can you explain what this demonstrative shows?
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Schnell testified about. This is actually a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike, again, happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number 1 spike, which is the biggest
Justice
spike,
for Johnny
was
Depp,
prior to the Waldman statements. So it's irrelevant to the case. And then the second thing I noticed that was interesting here is here are the dates in gray right here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, you know, his statement came out here in the first April 2020 article. Then the second one came out here, and then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020, and so on to the sixth spike going to April 2021. And what I did is, I don't know if you remember my last testimony when I went into Google search, and I'm able to go into Google search. I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them. Well, actually, I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with the Waldman statements.
Are you aware of Mr. Schnell's testimony that the tweets using the 4 hashtags he looked at were mathematically correlated?
Yes.
What does that mean?
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose, they tend to go up and down together. And that's why he had these spikes here. So the correlation there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements. And the fact that there's a correlation with the hashtags is irrelevant to this case because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
Oh! How do you know that the correlation doesn't have anything to do with the Waldman statements?
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. If when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here, and then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that there's no correlation because I analyze each of these spikes and none of them had to do with the Waldman statements.
Is mathematical correlation the same as causation?
No.
Why not?
I mean, correlation is simply a relationship between 2 or more variables or 2 or more things. In this case, the correlation question is, did when the Waldman statements were published, at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, again, Mr. Schnell provided no evidence of any correlation.
What correlation opinion did he provide during his testimony?
Well, he provided the correlation that the 4 hashtags, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the fact that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this. And as a matter of fact, during Ms. Arnold's testimony yesterday, she didn't even know what causation was. She was asked, do you know the difference between causation and correlation? And she said that she's not a semantics expert. We're not talking about the words. When it comes to damages, you have to prove causation prior to calculating damages. So there is no causation that's proven here. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
Well, he agreed that he failed to link the spikes in the hashtags on Twitter to the Waldman statements.
Did he try to do that?
He tried to do that. But again, his analysis was looking at the word Waldman and looking at the word Waldmanian, and then trying to say that 25% of the tweets included those two terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is, but it's not relevant to this case.
We can, I think, take that one down, please, Tom. Mr. Banya, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
Again, the assignment was to determine if the Waldman statements were part of the tweet, so I continued to dig in, to the data. I believe the next step is, now that I've excluded, the 35% that was before the Waldman statements because they were irrelevant, I wanted to really analyze from the April 2020 forward to see if any of those tweets, contained the Waldman statements.
Did you prepare a demonstrative that reflects that analysis that you did?
Yes, I did.
Your Honor, may I approach again?
All right, yes, ma'am.
Penso che oggi sia il giorno più devastante dall'inizio del processo, inclusa la controinterrogazione di Amber e incluso quello che hanno fatto ieri.
Any objections, sir?
No objection as a demonstrative.
All right, we'll mark it for identification as plaintiffs 1295 as demonstrative.
Gente di strada verso professionisti.
So, Mr. Banya, did you consider the content of the statements made by Waldman as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again, and what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. So what I went back to the Waldman statements, and I came up with key terms and key themes for those Waldman statements, which are listed here. The Waldman statements were about abuse hoax, sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets,
slabbrando l'ano di tutto il team di avvocati e testimoni di Amber.
And I determined that there were
Forbita espressione,
751 tweets that included those key terms, which is 0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a lot of these tweets had the exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore I eliminated any of those, and it came down with 95 unique tweets. And then what I did from there is I analyzed those to determine if any of these terms were in there, and I identified 5 tweets that were related to the Waldman statements.
Do any of the hashtags Mr. Schnell analyzed include the words from the Waldman statements?
No, they don't, and because I am rebutting Miss Arnold, her testimony yesterday, she was saying that the Waldman statements.
Devo dirti, Gennaro, che l'analisi che sta facendo lui adesso è meglio della sua stessa analisi precedente.
No, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These hashtags are only hashtags that Schnell, in his opinion, felt that they were negative towards Ms. Heard.
Si sta riscattando parecchio perché non aveva una bella opinione di questo tizio prima.
What are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right, it's going to be a little while, I assume?
A little bit more, yes.
Okay.
Yeah.
Let's go ahead and break for lunch, ladies and gentlemen, okay? Do not discuss the case and do not do any outside research, okay?
Ho dovuto staccarlo, chat. Ho dovuto staccarlo perché purtroppo si è alzato un angolo. Lo ristampiamo con il brim.
All right, we'll come back at 1:40 then. Is that right? All right, thank you, Your Honor.
Però che bello, non avevo mai stampato le scritte, è proprio bello. Proprio bello. Allora, fissiamo al volo queste impostazioni di stampa. Mi basta fare così. Brim. Ah, ecco qual è il problema. Ah. Classici, zona. What the fuck il bordo sulla A? Eh sì, mi dà problemi. Dai, risolveremo. 8 ore e 38 minuti. A che ora finisce? Quattro del mattino. Mi dispiace, chat, non lo vedremo finire oggi. Mi dispiace. Bellissimo però questo. Che palle tutti sti sprechi, mi fanno un fastidio, chat. È normale, senza contare che mi rendo conto che questi sono difetti, cioè sono errori di produzione che mi sto accollando io, ma chi poi stamperà questo file dopo di me non avrà i problemi che ho avuto io, per cui ricerca e sviluppo. Non puoi riutilizzarli? Guarda, purtroppo avevo tenuto anche quelli in passato, si può, ma ci vanno delle macchine molto molto care, per cui non ne vale la pena. E già che ci sono, io mi ricompro un'altra bobina di questo materiale perché mi è piaciuto e quella è già a metà. Ma oggi c'è stata una consegna? Oggi c'è stata una consegna? Ma no, ma non lo ricompro adesso. Troppo presto, ne ho ancora. Torno subito, chat. Vado a vedere se è arrivato un pacco oggi. E l'hanno messo nella buca delle lettere, ci scommetto. Nessun pacco. Eppure lo dà consegnato. Ah. Che palle. Il pacco è stato consegnato a un receptionist presso Giardino. Non ho la reception, ma ho i vicini stronzi. Un attimo. Datemi un secondo. Sì? Sì, grazie. Ho capito perché ho mal di testa. 100% il fatto che parlo a un volume troppo alto tutto il giorno. Ho sicuramente pagato le 9 ore di live, le 10 ore di live ieri parlando. Sicuro. No, ho trovato il pacco, ho trovato il pacco. C'è la mia madre in macchina. Voce rotta? No, pressione del parlare forte. No, Roxas. No, infatti non ce l'ho col corriere. Ragazzi, intanto stoppiamo la registrazione.